You're about to listen to a new episode of the Redefining Cybersecurity podcast with Sean Martin. Have you ever thought we're selling cybersecurity insincerely, buying it indiscriminately, and deploying it ineffectively? Well, perhaps we are. Let's look at how we can organize a successful information security program that integrates business culture with people, process, and technology to drive growth and protect business value.
Imperva is the cybersecurity leader whose mission is to protect data and all paths to it with a suite of integrated application and data security solutions. Learn more at imperva.com.
Pentera, the leader in automation security validation, allows organizations to continuously test the integrity of all cybersecurity layers by emulating real-world attacks at scale to pinpoint the exploitable vulnerabilities and prioritize remediation towards business impact. Learn more at pentera.io.
Marco.
Sean.
When was the last time you reviewed some law materials?
Well, let's see. So I'm a doctor in political science. I study a little bit of basic law, and I don't remember at the time any cybersecurity law. And the time was like in the early 90s. So no, the answer is no. Right? And I don't remember the last time.
Right. And I think a lot of things, even in a few short years, a lot has happened.
Oh, I would have
big
changed
things,
that
a lot
too.
of small things, a lot of overlapping things, a lot of conflicting things, a lot of things.
A lot of things happening.
A lot of things. And of course, if you want to do the right thing, you should probably abide by the laws that have surfaced over the past few years. So we're going to talk a bit about that, looking at law and cybersecurity, a bit of privacy as well, because I think a lot of the most well-known laws kind of revolve around privacy, and there's more to it than that. And I think we're going to get into some of those details today with our guest, Jim Dempsey. Jim, good to see you again.
Sean, Marco, great to be back with you.
And for those that don't know, we had a brief chat ahead of the RSA conference. Jim presented there, and we enjoyed the conversation with him. We wanted to get into more details, so we invited you back, and we're thrilled to have you back, Jim. Maybe a few words just to refresh folks about who you are, what you're up to, and then we'll get into it.
Well, I'm a lawyer. I always say I don't do technology. I do technology policy. I teach cybersecurity law at UC California, Berkeley Law School, which I've been doing now for, 6 or 7 years. I'm also senior policy advisor to the Stanford Program on Geopolitics, Technology, and Governance. And I am the proud co-author of the second edition of Cybersecurity Law Fundamentals, which was just published about a month ago, just in time for RSA, by the International Association of Privacy Professionals.
That's fantastic, and congratulations on that. I know it's a lot of blood, sweat, and tears goes into a project like that.
Exactly.
I don't know personally, but every story I hear from folks, there's a lot that goes in there. So, maybe can you give us an overview of what prompted you to pull this material together? Was there a need that you saw, or?
Well, yeah, it's a funny story, quote unquote, funny story. Like I say, about 6 or 7 years ago, I was at UC Berkeley running the Berkeley Center for Law and Technology within the law school. And after I was in that position for about a year, the assistant dean approached me and asked if I would put together a course on cybersecurity law for the LLM program, Master of Law program, which is mainly foreign students who are already bar admitted in their home country and come to the U.S. for a year or so to get an additional degree focused on U.S. law. Anyhow, they asked me would I teach a course on cybersecurity, and up till then, I had been mainly focused on the privacy side of things, government surveillance issues as well as consumer privacy issues. But I had sort of seen this very beginning emergence, particularly around breach notification laws, of something that you could call cybersecurity laws. So I said, sure, I'll teach the course. The first year, honestly, wasn't very good. I was still pulling it together, still trying to understand it, still trying to define it. But I think it did get better as I went along. And after about 2 or 3, 4 years, I had a whole set of PowerPoints. I had an outline. I had a structure. I had my own conceptualization of the issue. And I said, oh, this will be easy. Let me just take all my class notes, all my PowerPoints, each topic that I covered about 12 topics, 12 chapters. You got yourself a book. Well, 2 years later, I had a book. Partly because, one, the more I got into it, the more in depth I got, of course, and it wasn't just a matter of what I could fit on a PowerPoint. There was a lot more depth. Plus, I don't think there has ever been an area of the law, literally in the history of mankind, that has ever evolved and developed and progressed so rapidly as cybersecurity law. And
yes, so slowly.
So putting this together in the book was fascinating. And then what I started doing was maintaining a website, because I had to publish the updates to the book, because literally the minute I sent the book off to be printed, new things kept happening. So I maintain a website, cybersecurity.lawfundamentals.com, where I post regular updates. I did just one this morning. Yesterday, the SEC, Securities and Exchange Commission, issued a new breach notification rule for broker-dealers and investment companies who actually had not previously been under an SEC rule on breach notice, strangely, since most other sectors long since had been under such a rule. So I've been following the issue, and now, the first edition came out in 2021. Immediately, new things were happening. I was tracking them on the website, and it became time to do edition 2. I added as a co-author John Carlin, who's an attorney, now partner at the Paul Weiss law firm. But John has a long and distinguished and varied career at the Department of Justice, and in prior administrations really helped, including at the beginning of the Biden administration, helped lay the foundation for the current Department of Justice cybersecurity strategy. So adding John, who has tremendous on-the-ground experience, I'm sort of looking at this from an academic perspective. John brings in the hands-on, day in and day out advising of companies and his perspective, and then his DOJ experience. So I'm very proud of the way it's gone. It's at some level an incoherent body of law. We can talk about that more. It's a crazy quilt. But what I try to do is try to make sense of it and put it into sort of a framework.
So, can I?
Yeah, Marco.
Thank you. I'm just
you don't have to raise your hand.
No, I know. I normally don't do that, but because I'm thinking I'm in class with you, I had to raise my hand. So thank you. So I want to go back a little bit more. How do you apply laws when something is so new that there are no laws, right? So you get a car, there is no car. You're the first one in the car. Somebody yell at you and say, hey, follow the laws. And you're like, what laws? I do what I want. It's the car.
Yeah, no, that's
get me back into the beginning, even way before you wrote the book, when cybersecurity became a thing.
So, in the United States, at least, we have the common law, which is the law that we inherited, literally, from England. When we broke away as a colony and became an independent nation, we carried with us all of the existing common law of England at the time, and then our courts continued to take it forward. And you have tort law, you have contract law, you have law around fiduciaries, trust relationships. So you had this common law. And one of the principles of the common law is it applies without limitation. So artificial intelligence, we have no law of artificial intelligence in the United States, but the law of negligence applies, the law of contract applies. And on top of that, we had Federal Trade Commission Act going back to the beginning of the 20th century, which in very broad terms made it illegal to engage in unfair or deceptive trade practices. Now, deceptive, that's the relatively easy half of it. If a company says, we collect your data, we're a merchant, we collect your credit card data, you give us your credit card data, and we protect your data, or with e-commerce, the privacy policies or the statements the companies were making, don't worry, give us your data, we will protect it. And then they don't protect it, well, that starts looking like deception. So you take this concept from the beginning of the 20th century, and now you can apply it at the beginning of the 21st century. What is deception? And ultimately, the FTC got into the unfairness side, and they said, even if you don't make a promise, it is unfair to take somebody's data and not protect it. That is
which is what kind of happened to computer law, internet law, from radio law, which came from other law, right?
Intellectual property law. What is copyright? How does copyright apply to digital content? Right. So throughout the history of the internet, we have taken the existing law, started with that. Now then, Congress will come along, the state legislatures will come along, the regulatory agencies will come along, and they will add on top of that. And that's why I say you have this crazy quilt. You have some stuff that's 200 years old, 300 years old, and you have rules that were issued yesterday. And you have everything in between. And that's how you put these pieces together, and they don't fit perfectly. Absolutely. There are still gaps. Absolutely. But that's how we've built up this law. We started with what we already had, and the concept, a famous judge and law professor wrote an article a number of years ago called The Law of the Horse. It's not like we have one rule for horses and one rule for other types of property. We don't, he said it's better have good underlying concepts, good rules of contract, good rules of tort liability, good rules of copyright. And then if they're good enough, every time a new technology comes along, you do what lawyers do, you do what we all do really instinctively, which is you reason by analogy. You say, well, this is like something we saw before. It happens to be ones and zeros. It happens to be non-tangible, but we've had we've dealt with intangible harms for literally, again, for centuries. Reputation, privacy. Privacy goes back hundreds of years. Slander, taking somebody's data and using it to hurt them. That goes back hundreds of years.
So let me ask you this. I don't know how versed you are in it, but was it mid-80s, 1986 or something like that? The Computer Fraud and Abuse Act came out. And so I don't know what that is built upon, but that basically says you're not allowed to break into other people's systems and do harm, right?
Yep.
It's a conversation that we've had on ITSP Magazine many times, because there are good hackers, right? Ethical hackers that do use their brain, right, and tools to explore and see what things are vulnerable, and hopefully responsibly disclose what's going on there. Basically against that law in many cases. So how do individuals and organizations kind of navigate? Because I don't know that what kind of, I think there are some lawsuits, but I don't even know convictions. Anyway, I'm speaking out of my own realm here, but with the state of that, and I guess the question I'm trying to ask is, how do people and individuals understand the real intent of the law, where the lines are drawn, what really could happen to them?
Yeah, Sean, no, that's exactly right on point. I have literally a whole chapter in the book on the Computer Fraud and Abuse Act and other criminal laws. And as you say, it emerged in 1986, particularly 1984 originally. It was based in a way on some traditional concepts of theft, trespass, and injury. So it makes it a crime to steal our data from certain computers, to destroy data, to interfere with the operation of computer systems. Interestingly enough, it even applies to ransomware because it makes it a crime to extort, to threaten to cause damage to a computer in order to extort money. Yep. And it was built up again over the years. Congress started with a relatively narrow focus on government computers and then financial institution computers, and then vastly expanded it when they adopted the term protected computer, which is now basically any computer connected to the internet, any computer used in interstate commerce, which is the extent of the federal power over interstate commerce. Now, you're 100% right, Sean. You start out with terms like authorized, whoever accesses a computer without authorization, or whoever exceeds authorized access to a computer and thereby causes damage or takes information, copies information, etc., shall be guilty of a crime. And there were some notorious cases, which I traced the history of in the book. There were some notorious cases early on where people, ethical hackers, were threatened with prosecution. They were also threatened with prosecution under the Digital Millennium Copyright Act because what they were doing was alleged to violate copyright. Now, there's a remarkable...
Like with reverse engineering, right?
Exactly.
Yeah.
Exactly. And there has been a remarkable evolution there, partly through Department of Justice policy, partly through some lower court cases, and then finally in 2021, 2022, the Supreme Court decision, 2021 Supreme Court decision in a case called Van Buren, where the Supreme Court narrowed some of the focus of that statute. Meanwhile, on the copyright side, the Copyright Office issued some interpretations that narrowed the focus. And the government came to embrace the concept of the bug bounty. And the bug bounty being hack away at our system with the understanding that if you find a breach, you won't exploit it. You'll tell us, the system operator, that you found it. We may even pay you money for finding the flaw in our system. That's the bug bounty side. But the sort of responsible vulnerability disclosure is now government policy. Every government agency, the DoD actually, interestingly, was first to adopt that. And now every single government agency says, you are authorized to hack away at our system. Don't actually steal anything. Don't actually destroy anything. And if you find a breach, tell us. But if you meet those three conditions, you will not be prosecuted under this statute. That's a combination of both some of the courts being skeptical with these terms of service, and basically some of the courts rejected the notion that terms of service can create criminal liability. There may still be contract liability since the term of service is a contract. So fascinating example though, Sean, you're 100% right to single it out or pick it as one example of how You start sort of from some fundamental concepts of trespass, theft of property, destruction of property, interference with property, translate them to the digital world, and then it's not a direct one-to-one match, of course, and that's where the problems come in, that's where the questions come in, that's where the challenges come in.
And that's where a question I have.
Yeah, Marco.
Yeah, because everything before was tangible. And I have conversation about cyberbullying or other things that are cyber, and people feel like, nobody knows you are a dog on the internet, right? Like the old joke from the New York Times.
Yep.
But we do now.
Yep,
especially
exactly.
now.
Yeah.
And there is this difficulty, even in preaching cybersecurity to FA, MFA, and people like, I don't get it. I lock my door twice or lock my car, but why do I want to lock my phone twice? It's a pain in the butt, and so on. So I'm glad you went there, because I was just going to the kind of like the psychological aspect of applying concrete, real stuff into a digital world. Like how is that working?
Yeah, so you referenced telecom law. This is the whole question of sort of the evolution of the internet. The internet was never really a law-free zone. The internet was built on top of telecommunications law. The initial internet service providers benefited from some rules that the Federal Communications Commission had laid down regulating AT&T, which was the monopoly telco provider in the United States for decades and decades. And the FCC said, no, you've got to open up to interconnection, and you've got to allow anybody to hook any device to your network so long as it doesn't damage it. That decision became very, very important when people came up with the modem. And it became very important when people came up with the internet concept of an ISP. So we've always built internet law on top of the pre-existing law, and in a way the telecom law was built on top of postal law, et cetera. But it's never a perfect fit. That gets us into these questions. A lot of these harms are intangible. Although again, you go back, the concept of reputation always had an intangible element to it. The Supreme Court has an interesting decision on standing. They say that in order to get into federal court, you must have a concrete injury. But they say in the very next sentence, an intangible injury can be concrete. And a lot of what we're talking about...
Especially when the concrete is around your feet. And you're in the East River.
Now, one thing that's interesting about the evolution here is we've almost come full cycle now with the emphasis on OT. Everything used to be about IT, information technology, theft of data. Colonial Pipeline was a watershed moment, because attacking the IT system, the attackers there had an impact on the physical world, leading the company to shut down the pipeline. And that opened the eyes of a lot of policymakers to the vulnerability of our physical systems, which of course are now increasingly internet connected. Those cranes that you see at the major ports, the things that look like huge dinosaurs with the long necks that take the shipping containers off of the boat, put them on the dock, and vice versa. 80 or 85% of those cranes at American ports were made in China. Probably now every single one of those cranes has some internet digital feature to it. And so suddenly the potential ability of the Chinese government to force the makers of those cranes to deliver a software upgrade, which actually bricks the crane, turns the crane off, suddenly the digital vulnerability comes back around to a physical world vulnerability. And that's one of the major changes in focus. It's not like we've forgotten about the data vulnerability, but now cybersecurity has expanded from its origins in privacy law into or back to a concern with the physical world.
And Marco and I had a conversation. We were talking about the international geopolitical impact. Your selection of technologies, be it a crane, be it a network switch or whatever,
Yep.
Either put you at risk, put you in alliance with folks. It's very interesting. I want to, while I have you here, and of course you can come back for more conversations, but I want your thoughts on software liability. Because I think pretty much any product that you can think of has some liability where the builder provider offers some level of warranty, right?
Sure.
And if the warranty fails, you have some recourse, either money back and if you're harmed, then
Yep.
you have a case, right?
Yep.
Software, I think, is one of the only, if not the only, area where that's not true. So what are your thoughts on that?
Well, I think my own personal belief is it's time for the software industry to catch up with these other industries, as you suggest. And that's what the Biden administration called for in its national cybersecurity strategy of March 2023. The Biden strategy, 80% of it was probably the same as what was in the Trump strategy, which was 80% the same as what was in the Obama strategy, which was 80% the same of, going back literally decades across administrations. But in one way, two ways, but one way in particular, the Biden administration strategy marked a radical departure from prior consensus in calling for liability to be shifted from the users of software to the vendors, developers of software. And basically what the strategy pointed out was that the software developers have been able, partly as a result of their market power, but partly just nothing has caught up. They've been able, with terms in their contracts, or now licenses, it's all licenses, to disavow liability. So if you look at any software license, whether it's for personal use or more particularly for, more importantly, even for enterprise use, all of the software licenses say, we make no warranty about the performance of this, or very limited warranties, and we are not liable for any consequential damages. If the software crashes, you lose business, you lose your data, you suffer harm. We, the developer of the software, are not liable even if that was caused by a flaw in our product, even if we knew that our product was vulnerable, even if we knew that damage like this might occur. And those waivers, disclaimers, have been the norm and have stuck now for 20, 30, 40 years in the software development and marketing field. And consequently, as we all know, we're heavily dependent upon some pretty buggy software, software with flaws, and the developers do not bear the liability. The cost of those failures fall on the users. And the administration said it's time to change that, and the developers who compile these complex software programs should do a better job and should be incentivized to do a better job of eliminating flaws. Not eliminating all flaws. Nobody is claiming and nobody is expecting that there will be perfection. We don't have perfect airplanes. We don't have we don't expect perfection in any other field. But in as you say, I don't know if there's another field that quite enjoys the immunity that the software development field has been enjoying. And my argument is that may have made sense 50 years ago when the industry was in its infancy. May have made sense 40 years ago. May have made sense 20 years ago or 10 years ago. But now the industry has matured to a point and has become so obviously absolutely everything we do, personal lives, business, entrepreneurship, nation-state relations, democracy itself, all dependent upon software. And now getting there is not going to be easy. Although, Marco, again, my feeling is, let's go back to some of the concepts of tort law.
Yeah.
100 years ago.
Also known as common sense.
100 years ago, plus now, 1916, Buick Motor was brought into court, an early automobile. The wheel blew out or collapsed or fell apart. The car crashed, injury occurred, person sued. And Buick said, no, we're not liable. First of all, we didn't sell you the car. You bought the car from the dealer. We sold the car to the dealer. You bought the car. If you got a complaint, sue the dealer. The court said, no. You Buick, you made the car. You put it into commerce. You can't dodge liability. Secondly, and this is directly relevant to the way software is developed today, Buick Motor said, but we didn't make the tire. Someone else made the tire, and we went and just got the tire from the repository or the library or the warehouse. But sounds like how software is done. We just took somebody else's tire. And so, again, sue the tire maker. And Justice Cardozo on the Supreme Court of New York said, you car maker, you're the final compiler and assembler of all of these components. The burden is on you, based on amount of risk, to do due diligence and to inspect those components that you put together.
Otherwise, you can sell the car without the tires, and you said, you guys go and buy your own tires, and then you're responsible.
Yeah, exactly.
Can I ask you this? Because I know I'll pull you on the society, and Sean is pulling you on other thing, but there is the chapter that I'm looking at here, the topics, and it's related kind of to this, because you talk about defining reasonable cybersecurity, which is reasonable in air quote.
Exactly.
Actually, is in real quote in the book, I'm assuming.
Yeah.
But can we talk about that? Like reasonable?
So that, to me, that is one of the central questions of the evolution of this area of the law. Because as I said, whether you're the custodian of data, a bank, a credit card company, a merchant, a hospital, or whether you are the maker of a product, the standard is not perfection. The standard is good enough. And in the law, we call that reasonableness. And the automobile, the tire doesn't have to be perfect. The tire has to be reasonably safe.
Yeah.
Now, what does reasonable mean? Traditionally, at the automobile, we define that case by case, jury by jury, tire by tire. The car maker gets their expert. The plaintiff gets his or her expert. They say, well, what were the alternative ways to build the tire? Could you have used a better class of rubber or whatever? And if you chose not to take the reasonable alternative, was the product unreasonably dangerous or not reasonably safe? And we've sort of sorted that out with automobiles. It took 100 years. And by the way, we had the intervention in the 60s, 70s of the Federal Highway Safety Transportation Administration, which started issuing federal motor vehicle safety standards, which are now, there are hundreds of them, and they are very, very, very specific in defining what is a reasonably safe component. One of my examples, there's a federal motor vehicle safety standard on the boiling point of brake fluid. Your brake fluid in a passenger car cannot boil at a temperature less than X, whatever it is, 290 or 380 or 4 something degrees Fahrenheit. Because if your brake fluid boils, it vaporizes, vapor is compressible, and your brakes start working if your brake fluid has vaporized. Very, very, very precise standards, which we've built up. And you look at building codes and you look at all kinds of areas of human endeavor. We've built up these very precise definitions of what is reasonably secure. Because, by the way, if your brake fluid boils right above that limit, you're fine, even though it could be dangerous. Those little caps on the medicine containers, we have a standard that says the caps on the medicine containers cannot be opened by more than 80% of a panel of 4-year-olds in less than 10 minutes, which says that 20% of 4-year-olds can open them. We accept that because if no 4-year-olds could ever open them, no adults could too. So no one would be able to take their medicine. So we have these trade-offs. Where we try to define what is reasonable. What we are trying to do right now in the law, whether it's the electrical power grid or those Chinese cranes or software, we are trying to draw that line. And it's not easy. We're going ahead bit by bit, trying to define what is reasonable. And that's going to be a challenge now for the next decade.
Yeah, and I think kind of back to Marco's point of when we're talking about safety and human life, it's easy to make the connection between that and physical things, a car or something blowing up or whatever. When we get in the world of cyber, it's a little less direct and harder to visualize, I think, for a lot of people. And so if we can't connect it to physical harm, the other way to look at it perhaps is through monetary harm. And exactly. I think we see that with some of the stuff the SEC is doing. And there's another air quote, material
exactly
incident.
Exactly.
So the impact to people who invest money, right, yep. For a company that experienced a breach. So I could read the definition, but I'd like your view of what material means and is this going to make an impact, do you think?
So just to back up for the 0.0001% of your audience who isn't aware that the Securities and Exchange Commission has issued a rule requiring publicly traded companies to make public disclosure, basically to the investing public through their filings with the SEC, if they have experienced a material cybersecurity incident. And this is, again, taking law that has been around since the 1930s, when the Securities and Exchange Commission was created and our modern day structure of regulating the stock markets took effect. That whole legal system is based upon the premise that investors have a right to know what they're buying. They have a right to know about the financial condition of the company that they're putting their money into, or they're buying the stock of, which is why publicly traded companies are under this requirement annually to publish their financial data showing how well they're doing. And if anything changes from that annual report, you must do quarterly updates. And then if anything material changes, you must report within 4 days to the public, because the older report is no longer reliable because something your financial condition has materially changed. And again, material to the average investor. So we've got all these concepts: reasonable, material, average. But what we're doing again is we're taking them, and now what the SEC has basically said is, if a hurricane or a tornado hits your major warehouse, your major distribution point, and you're going to be shut down for weeks, that's material. So you have to tell the public, we got a problem. The SEC's theory is, if a ransomware attacker or another cyber attacker hits your computer system and shuts it down so you can't ship product for days or weeks until you recover and restore. The investing public deserves to know that. So within 4 days of determining that a cyber incident has had a material impact, you must let the public know. And then as additional information becomes clear about how bad the incident was, you must continue to update through these periodic updated reports. I think that makes sense. I think it created a lot of FUD, fear, uncertainty, and doubt. The SEC has tried to say, look, we're not going to try to play a game of gotcha here. It's interesting. I think companies have, in a way, started over-reporting. A number of companies have made filings in which they said, well, we don't think it's material, but we're publishing it anyhow. Okay, fine. I think that will settle out over time. But again, what is material? This is very interesting, you guys, because this is where for a company, now suddenly your CISO and your cyber team is talking to your corporate law team, talking to the folks who handle all the relationships with investors and stockholders and the board and the SEC, because it's not up to the CISO solely to decide what is material. You've got to have your chief information security officer talking to your chief SEC lawyer. And they've got to be able to communicate with each other, and they've got to be able to understand each other's language to make that determination, is this material? Which means that cyber...
We have our brain
I know.
going right
cyber,
now.
which means that's, yeah, exactly. Which means suddenly you see how cyber starts affecting a much wider scope of corporate governance. You obviously, long since, for the past at least 5 years, if not 10, it's been clear that cybersecurity must be a board level concern. And many boards, of course, have now created specific committees, subcommittees to address cyber issues, or else it's the audit committee who handles it. But certainly the board needs to pay attention to, needs to hear from the chief information security officer. And the board is on the hook, ultimately, for overseeing the cybersecurity operations of the company and asking the hard questions. So suddenly this issue, which had been a relative niche issue, starts taking on broader corporate-wide implications.
So we started wrapping here because we have to. Otherwise, we're going to keep going forever.
We could go, yeah, you could get me going forever, guys.
And maybe we will ask you to do something with us so we can keep doing it forever.
Yeah.
But, I want to go back to a couple of things that was the beginning. Like you said, this book is already, it's a book that never ends being written. And law is a never ending, right? I mean, with new things, new technology, new situation, new relationship, international, whatever it is.
Yep.
But we also forget, and I'm reminded many times by practitioners that we expect a lot from cybersecurity, which is a very relatively young industry. And we expect maybe too much from the CISO, and that's why burnout, and that's, and then I can go in a completely different story.
Yep.
But to maybe close with the beginning, what do you envision in coming up in the next few years? And is there a community of people in law like you that are, I mean, I'm assuming you don't have this burden all on your own, because that would be...
Yeah, well, no. Well, first of all, cybersecurity law has emerged now as its own discipline.
Right.
Still related in a way to privacy law, but in many ways different. And that's a major change from when I first started teaching the course and first started working on the book. Secondly, we've now got clear White House and congressional attention to it. Obviously, Congress has problems with being gridlocked on so many issues. But the Biden administration, and I think this would continue even under a Trump 2 administration, the executive branch is using the powers in the laws that it has, safety and reliability laws for telecom and railroads and pipelines and aviation, port security, laws, again, dating back 50 or 100 years, now being used to address the problem of, I mentioned, of the Chinese cranes. So you're going to see that whole process continue. You both alluded to the nation state aspect of this. So we are obviously in competition, particularly with China. There is a huge cyber element to that competition. We see TikTok is just the tiniest tip of that iceberg of data and hardware on sort of a global scale. So in all of these areas, there will continue to be development. Right now, Congress is considering a privacy law. I don't know if it'll pass, but it has a cybersecurity provision in it. We're now up to 18 states adopting comprehensive privacy laws, each one of which has a cybersecurity mandate in it. So it's going to be one of continuing evolution, development, and happy to come back at any time. When you see something hit your screen, a new development, maybe come on and try to contextualize it and explain it.
Plus, I don't know, Sean, 45 minutes, we didn't mention AI. I mean,
there you go.
There you go.
And we said privacy, we didn't say GDPR either.
Double drink.
Right.
Oh no, this was fascinating. Yeah. I'm glad that we had this conversation. Yeah,
and I think updates from you would be great. So we can figure out what that looks like, and I'm certain our audience would appreciate that as well.
Reach out anytime.
Our audience, if you want these, comment and ask. Yeah. We will. Maybe we will anyway, but we'd love to hear from you guys.
Well, I'm going to put the 100 questions in my head in a note, and we'll save them for future conversations.
Taking notes.
Loads of fun stuff here, and fun, air quotes.
Yeah, exactly.
Where we are.
It's interesting, though, and I think and fascinating. So people...
Well, and it's fascinating to see in real time how our society, and it's obviously happening globally, but just the U.S. society is developing a body of law in real time.
Mm-hmm.
To me,
while the airplane is flying.
Exactly.
You said that.
Exactly. We are building the airplane and modifying the airplane in mid-flight.
Yeah, which is kind of crazy.
It's fascinating.
Yeah. It is fascinating. All right. Well, Jim, thanks for coming back and taking this time with us, and
my pleasure.
Letting us point you. I felt like we were spinning you.
That's all right.
And go look over here now.
Good stuff. Yeah, I love it.
Super impressed with your level of understanding a lot of this stuff. Amazing. And hopefully our audience enjoys it. Audience, thanks for listening and watching this episode. And here on ITSP Magazine, many more. Please do subscribe, share with your friends and enemies. And Jim, we'll see you back. Marco, we'll see you soon.
Absolutely.
Yep, for sure. Take care, everybody.
Take care.
Pantera, the leader in automation security validation, allows organizations to continuously test the integrity of all cybersecurity layers by emulating real-world attacks at scale to pinpoint the exploitable vulnerabilities and prioritize remediation towards business impact. Learn more at Pantera.io.
Imperva is the cybersecurity leader whose mission is to protect data and all paths to it with a suite of integrated application and data security solutions. Learn more at imperva.com.
We hope you enjoyed this episode of the Redefining Cybersecurity podcast with Sean Martin. Please take a moment to rate the show and leave a comment. And remember to share the Redefining Cybersecurity podcast with your friends, family, and colleagues. Come back for more conversations and follow Sean Martin as he continues his journey towards redefining cybersecurity.